Hello, my name is Eric Hanscom. I'll be your instructor for the next 9 weeks. So let's start off week 1 by going over the differences between patents, trademarks, and copyrights. Now, a patent, to quote the statute, gives you the right to exclude others from making, using, or selling the invention in the country in which the patent is granted. A trademark, on the other hand, protects some sort of a name or a slogan or a logo that people see as being associated with some sort of goods or a company. And a copyright is a way that artists can protect their artistic creations. And this can be music, it can be a painting, it can even be a website. So those are the 3 basic types of intellectual property. Now there's also something called a trade secret. And a trade secret is something that is hopefully not discoverable by other people, but a trade secret gives you protection against, say, employees running away with your trade secrets and going to work for another company or something along those lines. So let's get into patents a little bit more. With patents, there are 2 types of patents that most people use, and those are utility patents that protect the function of an item, and there are design patents that protect the shape of an item. There's also something called a provisional patent. Now, as you may have figured out, a utility patent, because it protects the function of an item, is usually more valuable for the inventor than a design patent that only protects the shape. However, there are exceptions to that. And the first thing is that with utility patents, you're dealing with about a 50-50 chance of success with the United States Patent and Trademark Office. With design patents, you're looking more at 95% success. Also, design patents are usually examined more rapidly. It used to be about 7 months after filing. Now it's about a year to a year and a half after filing. And they're a lot less expensive to prepare and prosecute. Utility patents, on the other hand, again, about a 50-50 chance of success. They're usually examined somewhere between a year and a half to 2.5 years after filing. Now, with utility patents, there's also something called a provisional patent application. Now, a provisional application is basically a junior varsity version of a utility patent application. The provisional, it doesn't need official, beautiful drawings that you have to hire a patent illustrator to create for you. And it's fairly simple to write out. You don't really need claims in a provisional, but I always put them in because there are some foreign jurisdictions that require at least 1 claim in a priority document. If you want to use your provisional as a priority document, you should have a claim in it. So that's just a kind of a quick and easy way to do it. But the provisional gets you 1 year of patent pending status, and for a lot of smaller companies, that's a really useful time, because during that time you can seek investment, you can try to improve your invention, you can do all sorts of R&D, try to improve it. And because you can write the provisional a lot more broadly than you can write a utility patent, with a utility patent you really have to focus in on what the invention is right now. But with a provisional, you try to write it broadly enough so that you encompass what the inventor is doing right now and hopefully what they'll be doing a year from now. So that's kind of the difference between provisional, utility, and design patent applications. There's also something called a plant patent. And I've done 1 plant patent in my entire legal career, and I'll probably never do another one. But a plant patent is a patent that protects a new type of plant. And usually these are flowering plants, and usually these are roses. So that's why when you go to Home Depot or Lowe's, you can buy a regular rose plant or you can buy a patented rose plant. The patented ones usually cost about $3 extra because they have patents on them, as you may expect. So here's an example of a utility patent. These are the Super Freak surf shorts for O'Neill. And again, the idea here is surf shorts have been around for, well, at least 50 years. So here we wanted to protect the function of these shorts as opposed to the look of them. So anyway, good example of a utility patent. Now here's a design patent. I got this one for Steve Walden on his Magic model. Here, the shape of the surfboard is what's important. Now, obviously, surfboards have been around for a couple hundred years, in Hawaii at least, and so we couldn't we couldn't protect the idea of a wave-riding vehicle with a fin to steer it, but we could protect this particular shape. Here's an example of a trademark. This is one of my clients, Mullet on the Go, and they sell, as the name implies, mullets. So anyway, they wanted to protect this name so nobody else could call their company Mullet on the Go. Here's another example of a trademark. This is Birdwell Beach Breeches with, again, a little character that they wanted to protect so that nobody else could steal the name or steal this little surfboard character. This is what a patent looks like back in the old days before the USPTO started turning out electronic copies. They gave beautiful physical copies. This is actually my own patent here that I filed and prosecuted myself for a drone propeller with a winglet. So we have patents all over the wall of our office. These are a few. I think I've done about somewhere between 500 and 600 now. This is actually my office. So you can see there's more patents on the wall. And again, there are utility patents and there are design patents. Let's talk a little bit about why you might want to do a design patent. This is one of my clients' wheel pros, and you notice I have a whole bunch of different wheel shapes up here. And if you look at them, each one of them begins with a D. That's a design patent. So why did we get all the design patents for wheel pros? Well, because we can't get a utility patent on a round piece of metal that connects an axle to a tire. On the other hand, we can get a design patent on the individual shapes of each wheel. And so we can keep people from copying the shapes of these wheels by getting design patents on them.